Welcome back to US Updates Hub. If you are married to a United States citizen or a lawful permanent resident, and you are curious about how to bring your spouse to the United States permanently, or how to assist your foreign-born spouse in becoming a green card holder, right here on American soil, then this video was created specifically for you. Today, we are going to guide you through the complete marriage-based green card process in 2026, step by step, from the very start all the way through approval, including precisely what documents you require, what the actual costs look like this year, how long you should realistically anticipate this to take, and what has shifted under current policies that every couple must understand before they submit a single piece of paper. This is one of the most significant immigration journeys a family can undertake, and I want to ensure you enter it informed, prepared, and confident. So let us dive into it right now. First, let us discuss what a marriage-based green card actually is. When a United States citizen or a lawful permanent resident marries a foreign national, that American spouse has the ability to sponsor their partner for lawful permanent residence, commonly referred to as a green card. A green card permits the foreign spouse to live and work in the United States permanently. It is not citizenship, but it is a major milestone on the road toward it. And if your spouse is a United States citizen, the encouraging news is that there is no annual visa number cap restricting how many of these green cards get issued each year. Spouses of U.S. citizens are categorized as immediate relatives, which means they bypass the long waiting line that other family preference categories encounter. If your sponsoring spouse is a lawful permanent resident, meaning they possess a green card themselves rather than citizenship, the timeline becomes considerably longer due to annual numerical limits in what is called the F2A visa category. We will revisit that distinction because it matters a great deal to your planning. Now, as of April 15th, 2026, the landscape for marriage-based green cards has shifted noticeably compared to just a few years ago. The current administration has introduced a number of policy changes that affect how USCIS, which stands for United States Citizenship and Immigration Services, evaluates these applications. Comprehending those changes will help you file a stronger case and avoid surprises along the way. Let me be upfront from the start. Everything you hear in this video is general information. Immigration law is complex. Individual situations differ enormously, and immigration policy can and does change. Please verify current details with official USCIS guidance at uscis.gov, or consult a qualified immigration attorney for advice specific to your family's circumstances. This video does not constitute legal advice. Let us begin with the two main paths for obtaining a marriage-based green card. The path you follow depends entirely on where your foreign-born spouse is residing right now. If your spouse is already inside the United States and entered the country lawfully on a student visa, a work visa, a tourist visa, or another valid immigration status, then you can utilize a process called adjustment of status. This means your spouse does not need to depart the country. They apply to change their immigration status from whatever they currently hold to that of a lawful permanent resident, all while remaining in the United States. If your spouse is residing abroad and is outside the United States, then you will go through what is called consular processing. In this scenario, USCIS approves the petition in the United States, and your spouse then attends an interview at a U.S. embassy or consulate in their home country, and enters the United States with an immigrant visa that converts to a green card upon arrival. Both paths lead to the identical destination, but they involve different forms, different timelines, and different practical considerations. Let us walk through the adjustment of status path first, because it is the one that directly impacts couples who are already living together in the United States right now. The process begins with the American spouse who is called the petitioner or sponsor filing form I-130, the petition for alien relative. This form establishes the legal relationship between the spouses and notifies USCIS that the American spouse wishes to sponsor their partner for a green card. For couples where the foreign spouse is already in the United States and married to a U.S. citizen, there is a notable benefit. If one spouse is a U.S. citizen, you can file the I-130 and I-485 forms together in what is called concurrent filing. That second form, the I-485, is the actual application to adjust status to lawful permanent resident. Filing both at the same time can substantially accelerate the overall process compared to waiting for I-130 approval before submitting the second application. A significant procedural modification took effect in December 2024. The updated Form I-485 version now requires that the medical examination Form I-693 be filed at the same time as the I-485, rather than submitted later in the process. This is a practical change that affects how couples plan and budget for their application. In the past, you could file the I-485 and schedule the medical examination later. Today, you need to have your medical exam completed upfront with a USCIS-approved civil surgeon before you submit your package. Civil surgeons are licensed physicians designated by USCIS to perform these examinations, and you can locate one using the Civil Surgeon Locator tool on the USCIS website. One note of comfort for many families: the COVID-19 vaccination is no longer mandatory for Form I-693 effective January 22, 2025. That said, other vaccinations are still required, and the civil surgeon will review the full list with you. Along with the I-130 and I-485, couples filing from inside the United States will also want to consider filing Form I-765 for employment authorization, which would permit the foreign spouse to legally work in the United States while the green card application is pending, and Form I-131 for a travel document called advance parole, which in most cases would allow the foreign spouse to travel internationally without abandoning the pending application. USCIS now separates certain fees that were previously bundled for adjustment applicants, meaning fees for Forms I-765 and I-131 are no longer included as part of a combined I-485 filing fee. You will need to pay each form separately, which is an important budgeting consideration. Speaking of costs, let us discuss what this process is actually going to cost you in 2026. Because the numbers have increased, the minimum government fees for concurrent filing of the I-130 and I-485 total approximately $2,150 if you file by mail. If you also file for a work permit using Form I-765 and a travel document using Form I-131, the total rises to approximately $3,150. These figures are only the government filing fees. They do not include the cost of the medical examination, which typically ranges from $200 to $500 depending on the civil surgeon and your location. You will also need to budget for document translations if any of your supporting documents are not in English, passport-style photographs, mailing costs for certified mail, and attorney fees if you choose to hire professional legal assistance, which many families choose to do, particularly given how complex and high-stakes the process has become in 2026. The important takeaway is that the total out-of-pocket cost for a marriage-based green card filed from inside the United States in 2026 is realistically in the range of $3,000 to $5,000 or more when all expenses are considered. You can always verify the current official government fee schedule using the fee calculator on USCIS.gov. USCIS warns that incorrect fees remain one of the most common preventable problems. And even when a marriage is genuine and the forms are otherwise properly completed, the wrong payment amount can result in a rejection that delays the entire case. Each form must be paid separately. Double-check the current fees on USCIS.gov before you prepare your payment, and make sure you are using the most current version of each form. USCIS states clearly that all pages of a form package must be from the same revision version to avoid rejection. You can verify this by checking the form number and edition date printed at the bottom of each page. Now, let us discuss what documents you need to assemble for your application. This is where strong preparation truly pays off. You will need your marriage certificate, proof that any prior marriages for either spouse have legally ended through divorce decrees or death certificates, birth certificates for both spouses, passport copies, evidence of the U.S. citizen or permanent resident spouse's immigration status, such as a U.S. passport or naturalization certificate or green card, and evidence that the foreign spouse entered the United States lawfully, such as an I-94 arrival record. Most importantly, you will need a substantial collection of evidence that your marriage is genuine. Evidence of a bona fide marriage typically includes joint financial accounts and shared financial responsibilities, lease or mortgage documents showing you live together, insurance policies listing each other as beneficiaries, photographs from throughout the relationship, and correspondence records. Think of it this way. USCIS is searching for documentation that tells the authentic story of your shared life together. The more consistent, organized, and comprehensive your evidence, the stronger your application will be. USCIS has intensified security vetting for green card applicants, including background checks and screenings for potential fraud, and has increasingly reviewed social media accounts as part of that vetting process. This means it is worth being thoughtful about what your social media presence reflects and ensuring that information you present to USCIS is consistent with your public digital footprint. No one is suggesting you do anything other than present your real life honestly. Consistency and authenticity are your greatest allies. One of the most significant changes in 2026 is the return of mandatory in-person interviews for marriage-based green card applicants. Under current USCIS policy, the agency is requiring in-person interviews for virtually all marriage-based green card applicants, regardless of how complete or compelling the documentary evidence may appear. During much of the previous administration, interview waivers were routinely granted in well-documented cases, with some practitioners reporting waiver rates well above 90%. That era has now concluded. Starting in early 2026, USCIS updated its policy manual to dramatically restrict the circumstances under which interviews can be waived, with the stated rationale being strengthened fraud detection and enhanced national security vetting. Both spouses must appear together at the USCIS field office interview. Officers will ask questions about how you met, your wedding, your daily life together, your living arrangements, finances, future plans, and other aspects of your shared relationship. They may ask each spouse questions separately to assess consistency. This is not something to fear if your marriage is real and your documentation is thorough. Prepare together. Review your application before the appointment and answer every question honestly and directly. If you genuinely do not remember something, it is perfectly acceptable to say so. Significant inconsistencies in the accounts of both spouses, on the other hand, can raise serious concerns. Officers are also asking more questions about travel history, ties to foreign governments, and social media accounts as part of expanded vetting protocols. In 2026, come prepared with original documents including your marriage certificate, birth certificates, passports, joint financial records, and any additional relationship evidence you have collected. Now let us discuss the timeline. How long will this actually take? Marriage green card processing times in 2026 range from approximately 12 to 33 months depending on your filing location, your case type, and whether your spouse is a U.S. citizen or a green card holder. For couples where the sponsoring spouse is a United States citizen and both spouses are inside the United States using adjustment of status, the total process typically takes 8 to 14 months from start to finish in 2026. Though timelines vary by USCIS field office, some field offices process cases faster than others, and you can check the current processing times for your specific local field office using the Processing Times tool on uscis.gov, which is updated regularly. For cases where the foreign spouse is abroad and going through consular processing typically takes 14 to 18 months after the petition is approved, though embassy backlogs can extend this timeline considerably. For families where the sponsoring spouse is a lawful permanent resident rather than a U.S. citizen, the timeline is dramatically longer. The I-130 processing time for permanent resident sponsors can average around 35 months, and after approval, the foreign spouse must wait for a visa number to become available in the F2A category, which as of 2026 is experiencing significant backlog. If you are a green card holder sponsoring your spouse and you are eligible to apply for U.S. citizenship, that is worth considering seriously because becoming a citizen would reclassify your spouse as an immediate relative and eliminate the F2A waiting period entirely. There are several factors that can slow a case down beyond the standard timeline. Missing or incorrect documents remain the number one cause of delays. If USCIS sends a request for evidence asking for additional documentation, that adds approximately 2 to 3 months to your I-130 processing time automatically. Take the time to prepare a thorough, well-organized application package from the start. Background checks and security clearances can also extend processing in certain situations. If your case involves any prior immigration violations, criminal history, prior marriages, or complexity of any kind, it is especially important to seek professional guidance before filing. There is one additional consideration for couples navigating consular processing. In early 2026, the Department of State announced a pause on visa issuance for individuals from a specific list of countries based on public charge concerns, which went into effect on January 21, 2026. This visa pause does not apply to those who are applying for green cards at USCIS within the United States through adjustment of status. It only affects individuals applying for green cards through consular processing abroad. If your spouse is from one of the affected countries and is applying from outside the United States, their case could face significant additional delays. This is a rapidly evolving situation, and I strongly encourage you to check the current USCIS and Department of State guidance and consult an immigration attorney if your family may be affected. Once your green card is approved, there is one more important distinction to understand. If your marriage was less than 2 years old at the time your green card is approved, you will receive a conditional green card valid for 2 years rather than a standard 10-year permanent green card. Conditional green card holders must file Form I-751, the petition to remove conditions on residence within the 90-day window before the card expires. That petition asks USCIS to remove the conditions and issue a permanent 10-year green card, and it requires additional evidence that the marriage continues to be real and ongoing. Missing this deadline can create serious immigration consequences, so mark that date on your calendar the moment you receive your conditional green card. And then, once your conditions are removed and you hold a permanent 10-year green card, there is a meaningful benefit for spouses of U.S. citizens. If you are married to a U.S. citizen, you may be eligible to apply for U.S. citizenship after just 3 years of holding a green card, rather than the standard 5 years that applies to most other green card holders. That is a significant advantage that many families are not aware of. Let us recap the practical action steps you should take right now if you are beginning this process or preparing to file. First, determine your path. Is your spouse inside the United States on a valid visa or outside the country? That determines whether you are using adjustment of status or consular processing. Second, check the current form versions and fee amounts on USCIS.gov before you file anything. Form versions and fees are subject to change, and filing the wrong version or incorrect amount will result in a rejection. Third, schedule your medical examination with a USCIS-approved civil surgeon as early as possible, since this is now required up front with your I-480 application for adjustment of status cases. Fourth, begin gathering your relationship evidence now, including joint financial records, shared housing documents, photographs from throughout your relationship, correspondence, and affidavits from people who know you as a couple. The stronger and more consistent your documentation, the smoother your process will be. Fifth, use the USCIS processing times tool at USCIS.gov to look up current timelines for your specific field office or service center and set realistic expectations for your family's planning. Sixth, prepare together for your interview by reviewing your application and aligning on the facts of your shared life. And seventh, seriously consider consulting with a licensed immigration attorney, particularly given how significantly the landscape has changed in 2026. This is not a requirement, but professional guidance can help you avoid costly mistakes. Before we close, let me offer a brief but important disclaimer. Immigration policy and processing times can change significantly and sometimes quickly. The information in this video reflects conditions as of April 15, 2026, based on publicly available USCIS guidance, Department of State announcements, and reporting from credible outlets. Always verify current requirements directly with official sources, including USCIS.gov and travel.state.gov. And for your individual circumstances, please consult with a qualified immigration attorney or accredited representative. Nothing in this video is legal advice and individual situations differ enormously. That brings us to the conclusion of today's update. This is a journey that millions of families take every year. And for couples with genuine relationships, solid documentation, and careful preparation, it remains absolutely achievable even in this more demanding environment. Yes, the process takes time. Yes, the fees have increased. Yes, the interviews are more rigorous than they were a few years ago. But for couples who are building a real life together, that is exactly what this system is designed to recognize and reward. Your patience and your preparation will carry you through. If this video helped you understand the marriage green card process in 2026, I am asking you to do 3 things right now. Hit that like button because it helps other families who need this information. Find this video. Share it with anyone you know who is going through this process or thinking about it. And subscribe to US Updates Hub so you never miss a critical update. We cover USCIS announcements, visa bulletin movements, policy changes, and practical guidance every week because we know how much is at stake for you and your family. Check the video description for links to official USCIS resources, the Processing Times tool, the Civil Surgeon Locator, and the official fee schedule. Everything you need to get started is right there. Thank you for choosing to spend this time with us today. On behalf of all of us at US Updates Hub, we wish your family every success on this journey. Stay informed, stay prepared, and we will see you in the next one. This content is for educational and informational purposes only. It does not constitute legal advice. Immigration laws and policies are complex and subject to rapid change. Individual situations vary significantly. Always verify information with official government sources, such as USCIS at uscis.gov and the Department of State at travel.state.gov. Consult with a qualified immigration attorney regarding your specific circumstances before making any decisions.